Nice to meet everyone. My name is Kasey Kuhlman. I'm a lawyer and I work in, I do a lot of different things, but the main thing that I have going on is I run a very small law firm in Somalia. I'm in Holland a lot because my wife works at the International Criminal Court down in The Hague. So I spend probably half my time or so up in Holland, and then about half my time down in Somalia. I'm very interested in cryptocurrency and blockchain technology for a variety of reasons. Number one is because I operate in an environment which has what a lot of people would consider to be a relatively immature rule of law scenario. And so that's one reason why I became interested, because one of the things that is often touted as an advantage of blockchain technology is that it can be of assistance in areas where the rule of law is not as developed. I think, from my own perspective, I think the verdict is still out on that one. But more clearly, or I mean more relevant, is that last summer, one of the big remittance company that allows really us to work and was faced with a situation where it was going to have its bank account closed by Barclays, its big bank, because of compliance concerns. And this was originally how I got interested in blockchain. I mean, in blockchain technology, and specifically Bitcoin at that point, because there were some ideas at being able to do international transactions outside of the confines of banks. And so that was very interesting to me. And that's kind of how I originally came to understand about blockchain technology and approach things from a lawyer's point of view. And so what I'd like to do tonight is to talk through how I think about contracts at a real base level. One of the things that I really like about living in a developing country is that it allows you to strip off a lot of the superfluous layers to systems. So I've been forced to figure out, or been forced to understand environmental interference of microwave transmission of internet technology, because that's how we get our internet. But every time a sandstorm comes, our internet goes down. That's something I never would have learned if I weren't calling the telecom company and complaining that our internet was not working. I've been forced to learn about resiliency of your supply chain because I bought a gas cooker, and the ship that was going to bring in a year's supply of gas sunk in the harbor because they hadn't dredged it. Things like this are one of the greatest things about it, in my opinion, about living in a developing country, because you really get to look at the core of why systems work. And my legal practice is the same. I tell people a lot that, in my opinion, it takes more skill to understand and to make contracts that work in a system that doesn't have a lot of constraints, legal constraints on it, than it does in a system that might have more constraints. And so, since we're in the very early phases here of Ethereum, I wanted to talk through how I approach contracts in an environment that has very little external constraints. And because I think that is more or less the world that we are going to be living in Ethereum for a little while, until more constraints get developed. So what I want to do was to talk through 3 rules that I generally think about when I'm developing contracts, or I'm reviewing contracts, or I'm negotiating contracts. So the first rule, use your funnels. Now, I wanted to ask, how many in this room identify as coders or programmers? Yeah, huge. And who in this room identifies as a lawyer?
I studied law.
Okay, cool. That's awesome. We're not all evil, I promise. Some are, but not all of us.
Says the lawyer.
I'm not evil. And if you become my client, I can prove it.
It's still coming from a lawyer.
Of course. So a lot of people in this room are technology focused or identify as programmers or coders. And coders understand stacks well. You have things within the stack that move memory references around or do the very core elements of a transaction, of a process transaction. You have things higher at a little bit higher in the stack that make your data accessible or make your data so that you can do things with it. And then you have things higher in the stack that do other things, such as make things look nice or look pretty. And that's the stack as most technology people might think of it. In law, we have a stack too, and our stack is a little bit different. So when we think of a stack for a lawyer, what we think of is norms that either compel action or that compel inaction. So if we graph those norms based on the number of actions that a norm can compel and the number of actions that a norm can prohibit, against the specificity of the norm. Sorry, I'm on this little pen, but anyway. Against the specificity of the norm. You have things like constitutions, right? And they can compel or prohibit a lot of action, but in general, they aren't very specific, okay? So you have things that are, constitutions. You also have things that are treaties. And they can compel a lot of action, but again, they are not very specific. You also have laws that parliaments pass, and they're a little bit, they can compel, again, lesser amounts of action or inaction, and they're a little bit more specific. And as we go down this list, here we have decrees that ministries do, and then we get into different things such as commercial norms. And again, we're just bringing down the funnel here, right? And then finally, we get into the terms of any particular contract. And contracts have different levels of specificity depending on what they're talking about, right? So when we look at this as lawyers, what we do is we break this down into two different portions of the funnel. The first part of the funnel is the part of the funnel that we can't really control. It's outside the control of any individual party that's wanting to contract. And this I call this part the compliance funnel. And then you have the part that you can control, and that's the contracts, right? So it's the compliance part is outside your control, but you have to take it into account. Now, this changes depending on what contract you are looking at. If it's an employment contract, you have to take certain sets of into account. If it's a different kind of contract, then you have to take those norms into account, and it'll have different sets of norms depending on the subject matter, depending on the jurisdiction or the geography in which the contract is going to take place, and it's going to vary on other things. So the size of the contract piece and the compliance piece, those will change over time, over geography and over subject matter, as far as which proportion of the entire funnel they take into account. So even though I work in a country like Somalia, which has a very low level of, which doesn't have a lot of legal norms, especially in comparison to the United States or a European country, I still have to make sure that I comply with whatever norms there are. Now, this is more or less how it works for lawyers. Now, why is this important and or relevant to the coders in the room? Well, a lot of people try to avoid laws, right? They think, well, okay, I don't like the law, it doesn't work for me, so I need to avoid it. Well, that's fine and well and good, and I don't really necessarily take a position on that. But one of the things that the law can do for you is that it can provide a shorthand for you. If you needed to build a contract that had every single thing that could go wrong with that contract, and you needed to build that into the contract, you would have a 1,000-page contract for a very simple transaction. But you don't necessarily need to do that, because you have laws, you have constitutions, you have treaties, you have commercial norms, you have laws that are passed by Parliament, decrees that are passed by ministries, and other things and these things provide the framework in which you operate, which gets me back to what I started with, which is the stack. And at this point in Ethereum, where we are is at a very, very early stage. You know, the first time that, pick any language that's not an ultra-modern language, the first time that someone tried to build a web server in that language, they had to code a heck of a lot. It was a very long code base. The second time that someone tried to build a web server, they could rely upon the guy that built the first one, and they could make, or the woman or whoever, they could make changes. And over time, maybe those the core of what was needed was pulled into a standard library for that language, and then over time maybe packages were built, third-party libraries, and over time you get to the point where in most modern scripting languages you can build a web server in 3 or 4 lines of code if you're relying on the standard libraries and third-party libraries. And it's the same in contracts. The first time that someone had to write an employment contract, if he was doing it, or she was doing it appropriately, it would have been a really huge contract. But over time, he or she would have been able to write less and less and less and less, because of the compliance part of the funnel takes a lot of the burden out of the programming of the contract, just like the stack allows people to focus on what they really need to focus on. So,
one small thing.
Sorry?
I agree with you with what you said, but I think, correct me, everybody in this room is a programmer.
Yeah.
If that was the case for the programming, then the programs will become smaller and smaller. And that's actually the other way around. What you see is that the complexity of the application are becoming much more and more, and programs are becoming bigger and bigger.
Mm-hmm.
So the simplicity of programming, yes, it is becoming simple and simple. But the amount of code that you write and the complexity is just increasing. I think with Ethereum would be the same. The complexity of the contracts would be just increase and increase. It won't become simpler, I guess.
we will see. I'm a lawyer that likes to code in my spare time. I don't consider myself an expert on anything on the technical side at all. And obviously we are all new to Ethereum, so we will see. I definitely take your point, but I think probably what is happening is that the funnel is expanding. So as the funnel gets bigger, everything has to get bigger. You know, if you have a very small amount of things that programs are trying to do, yes, it's probably less and less code. Of course, you can't write a really viable application in 4 lines of code. That's not what I'm trying to imply. But you can write a simple server that serves a simple page in 2, 3, 4 lines of code. And that's all the point I was trying to get at. Was that, and I definitely agree very much with what you're saying. The other reason that so why is this important for Ethereum or at this meetup? Well, I think that there are 3 reasons about the funnel that make Ethereum quite interesting to me. First off is that right now where we are in Ethereum is that it is all the contracts portion of the funnel. We don't have any sort of compliance portion of the funnel at this point that we have to deal with. And this presents for a very interesting set of possibilities. As to what will happen in the future, I have absolutely no idea, but I suspect that different types of frameworks or framework-like things will develop over time for contracts, and really not necessarily individual contracts, but for sets of contracts. And that's where I think things will get quite interesting. And at that point, you will be able to choose from different legal ideas or different philosophical ideas about contracts or about transactions generally. And you can rely and build your incentive structure based upon these differing ideas. And you can change down the road if you have enough engineering time and or lawyer time to pay for it. Like Twitter started on Rails and then they went to whatever they are on now. And it took a lot of engineering time, but by the time they needed to get off Rails, they had a significant amount of money and they could afford to pay for the engineers to do that. If you're a small startup, you can decide if you want to program in any number of frameworks right now, and you can weigh the different advantages and disadvantages for you based upon what you are trying to accomplish. And what I'm very excited about Ethereum is that it will be able to give us this possibility of testing out different things. Nick and I were talking before the talk about how will this work in terms of sort of norms and how will different norms develop. I don't know. I can see it operating in probably one of different ways, but I suspect there will be probably 2 paradigms that will develop. I think that similar to how many people may just use Google's hosted versions of jQuery if they want to push something out quickly, then I think reference contracts that exist on the blockchain will develop, and if you need to push a contract out quickly, but you want to be able to reference the library of norms that exist within that contract, you should be able to reference it back and forth. If you're doing something a little bit more complex, probably you're going to need a system of contracts or a framework of contracts, like any framework that works for your particular system. And I suspect those will live off the blockchain in various GitHub repos or in corporate Git repos or whatever version control system you use, and then they will get deployed as a system to the blockchain. That's just my idea. We don't know. But the real thing is that for us as lawyers. funnels are to us what stacks are to programmers. The second rule is to keep contracts social. And I don't mean social in the terms of those icons at the bottom. I'm sure they are trademarked, and maybe I'm violating all kinds of trademark by using them. But in any event, what I really mean is the essence of that word before social media was a buzzword that people used. Contracts are fundamentally about providing rules for interaction, and what that allows us to do is to develop individuality and also precision within the face of a complex set of social interactions that is the everyday world. And in order to deal with this, what I always do is I always break a contract down and I look at really three things in this area. I look at who are the parties, what do they have going on, what are their incentives, which is the second piece, and then I look at what are the possible outcomes that one can reasonably expect from this interaction, and then what are the possible outcomes that one cannot reasonably expect from this interaction. The real science of doing a contract is the first rule. That's really making sure you stay within the funnel. The real art of doing contracts lays in this rule. And this is where contract design gets complicated for lawyers. But it's something that is not any more complicated for a lawyer than for anybody else. And I think that this is something that most people can fairly have a good framework for thinking through. Once they think through what are the incentives to perform and what are the incentives that the other party needs to perform, then it's fairly straightforward. More in many instances, it's fairly straightforward to develop a contract that can provide the right incentives. One of the things that I think it's important to think through is what makes an effective contract. You know, what does a contract designer think through as far as how does that contract designer succeed? It's not necessarily if he passed tests, you know, in the test-driven design sense of that word. It's not necessarily that. That's more on the science side. Really, what a contract designer wants is that this contract doesn't go to court. And so that means one of two things to a contract designer. Either it means that there was full performance and the contract expired without any breaches, or there was a breach, but it was what's called an efficient breach. In other words, there was a breach, but that party that breached paid or did whatever the consequences were of that breach, and then everyone carried on with their existence. But the real key here or the thing that I think through a lot on this is is in comparison to oral agreements. So as I said, I work in the Horn of Africa. There, oral agreements predominate, and in that context, I've as a guy that hopefully gets paid to write and review contracts that are written, I've tried to figure out why are there so many oral agreements. A lot of my clients have gone into multi-million-dollar businesses and have made multi-million-dollar investments based on completely just yes. Just that's it. Which coming from being American, coming from America, blows my mind to to a great degree. And so I've asked a lot of people, why would you invest so much money based on just an oral agreement? And people have told me, well, trust. If I ask for a written contract, that is telling the other party that I'm going into this venture with that I don't trust them. And then that's a bad place to start for me. So I'm being told, not for me as an individual. And so I have typically responded with, well, yes, that's great, but that oral agreements have a problem, and the real problem is memory bias. I remember things one way, you remember things another way, and that's well and good, and it makes for a difficult situation. When everything is going fine with the business, everything's going fine, and no one really complains. But when you have a shock to the business, then things get difficult, and so that's where written contracts come into play. And I may say something controversial at something like at a meetup such as this, but from my perspective, to a limited extent, those people have won me over, and I sort of respect where they're coming from. I think that human-to-human trust is very important, and I think it's important because it's efficient. It is much. It doesn't need electricity. It doesn't need communication. It doesn't need paper. It doesn't need enforcement. What?
It doesn't need lawyers.
It doesn't need lawyers. It doesn't need lawyers. That's right. A lot of negativity towards the lawyers.
No. It's just a statement.
Yeah, no, it's true. So says the negative Nellies. But trust is actually really efficient. It doesn't need a lot of these things in order to make it work. And a lot of crypto technology is based upon how can we break down trust. I, as an individual, think that trust is something to be lauded and to be respected. And I always try to build my contracts in a way that can allow people to develop trust on a human-to-human level while also providing a backstop as to what would happen afterwards. And that can give us all some precision if bad things happen. And so that's really the core of what I think through as far as how can we make this interaction between some human beings hopefully be successful. Now, why is this part important for Ethereum? Well, on the one hand, I think that that the idea that Ethereum Ethereum is a platform for smart contracts is important, but I take a slightly pedantic issue with calling them contracts because they aren't necessarily contracts. If anyone has seen the screencast or reviewed the marriage contract that was developed by people in the room, then a decent part of that contract, of the code within that contract, was actually to make it a contract. And that portion which required an offer by one party and an acceptance by the other party is actually what made it a contract as I would think through a contract. Ethereum by default does not require that. And so I think about Ethereum as a platform of unilateral promises. And again, that's a little bit pedantic of me. I understand, but contracts are they do actually require one person to say, "I will promise you this if you promise to do that," and the other person saying, "Yes, I agree to this." And in that point, you have a meeting of the minds. But before that, you just have an offer. and that human interaction, or that interaction between any two entities, whether they're human or robotic or corporate, it is actually important for the system. And so the other thing that I think that is very interesting for Ethereum is really what are the different interactivity points between contracts or set of contracts. I don't really know how that will play out, but it will be interesting to watch.
But aren't contracts are? But aren't unilateral promises actually part of contracts? Aren't contracts made of unilateral promises?
No, generally no. They're reciprocal. They could be thought of as reciprocal unilateral promises, but the reciprocity component is key to actually having a contract in most jurisdictions that I know of. So if I say I'm going to give you $100 at the end of this, that's not an enforceable contract. In most jurisdictions.
Unless there's agreement.
Well, unless there's agreement, no, unless there's some level of counter performance as well. And that was a bad example in the context of your question, and what I'm trying to drive at, which is that there does need to be some bilateral promises. So if I say I will give you $100 at the end of this lecture if you do not drink a beer, then okay, that is, and you accept, then that is an enforceable contract because you have said I'm going to give up something or I'm going to do something. I'm going to either act or not act, and so that is then you have some bilateral interaction.
So it's basically also the same that, okay, I'm going to give you $100, and if I don't give you that $100 at the end of the talk, then this happens.
Hostage negotiation.
Yeah.
That again, that's a unilateral promise.
Oh, okay.
That's not if you just say you're going to give me $100, and I'm not doing anything for that $100. That's in law we would call that a gift. Probably in Ethereum we may call it a contract. I don't know. But as far as enforcing contracts outside the context of the Ethereum blockchain, that would be difficult to enforce.
But what you're saying in a nutshell is this: we can promise each other eternal love.
Mm-hmm.
But the blockchain and
I don't do that to people that have beards,
and,
though.
And the blockchain and libraries will back it up.
Yeah. All right. Well, let's see.
Instead of like we're just having a contract and we're just saying yes and nobody is here and we're just having a verbal agreement, the blockchain will back it up, or will be the ears, and you can say, well, we said I love you, there was nobody there, but there was 5 other persons verified our transaction.
Yeah.
And we're going to make it simpler each time because we're going to build common libraries. Okay, so I'm understanding it.
Well, I think these two, the first rule and the second rule, are somewhat related, but probably a little bit distinct from each other.
Okay.
So then the last one, and this will be a little bit faster, is define the decision space. I think of contracts as having, and I think also of organizations and systems as having various decision spaces, which I think of as Venn diagrams. Each individual node within this system, they have decisions which they are supposed to take that are fully within their own decision space. And then they have other decisions which are shared decisions that are overlapped with another node within this system. And in traditional contracting, this is very difficult. If you have an employment contract with your employer, probably you have very generic duties. Your employment duties are quite generic. Maybe they're very specific. I don't know, but a large proportion of employment contracts are fairly generic. They won't say on this day you will do that. And consulting contracts similarly are that way. And the difficulty is that if you want to change that decision space, then you would have to pass an amendment to the contract. And that would take a whole process that your employer or the contracting parties would have to go through. This is the area which I personally think that Ethereum can really shine, because it can introduce some dynamism to this. Because contracts can modify their own code if they are programmed to do so, this allows for a very interesting and fluid set of decision spaces. So if you have a decentralized autonomous organization and a new position is created within that, and decisions that used to be given to a different node within that system are then given to this new node that was created, and either unilaterally or bilaterally shared decisions, then you can move those around within, if the contracts are programmed so that they can modify themselves, you can move those decisions around in a way that optimizes for the organization, which you can do a little bit in traditional contracting, but it's very static. Essentially, once a contract is deployed or signed and agreed, it takes a lot more to change it than it would in a dynamic system like Ethereum. And that's really the third thing. So so those three rules. If I'm doing a transactional contract, or if I'm doing a corporate governance agreement, or I'm doing an employment contract, I always try to keep in mind these three things. And they're abstract, they're a little bit conceptual, but I think they apply to almost any contract that I, for one, have seen. And so, anyway, that is really what I wanted to talk through. And the last thing I'll say is that we're not all bad, as I said. There are a ton of bad lawyers, I guess. But Internet Explorer was a
His wife is a
6.
lawyer, so.
Oh, really? Internet Explorer 6 may be the bane of your personal existence. I don't know, but there's also Chrome and Firefox and modern versions of that. And I would definitely encourage anyone in this room, if you have friends that are lawyers, or if you have wives that are lawyers, or really anybody that's a lawyer, it would be great if they came. Because if Ethereum is going to work, there needs to be sort of a balance of thought between a lot of different ideas, from the economic side, from the legal side, from the technology side. And as we saw at the beginning of the talk, we've got me on the legal side and a couple others maybe. So having some balance of thought is really probably how this system can succeed. So thank you very much.
That was really interesting, man. Thank you.